other SDOs to come to similar agreements. There are advantages for all. There is more clarity about what prior art in fact is. You cannot steal the idea away during these working sessions. There is a prompt access to the standards documentation, so efficiency is enhanced, and also all kind of opposition processes, litigation, legal uncertainty is prevented by using these standard organization documents. You see in this graph the increase of numbers of documents that have been cited by the EPO as prior art, which shows that we have been successful in getting this as an important source for our searches. Here to complement, you see about the same development, but now you can also see the different databases which are, for example, you see the XP-EE showing how many patents are cited from these standard setting organizations. So to conclude, we have established clarity on the legal status of standards documentation with a number of standard setting organizations. We have acquired a big part of prior art which can be searched, and it is increasingly important for a wider range of technologies, which includes, very importantly, a lot of ITC-related industries. We are keeping on going on to expand this cooperation with standard organizations. And I have to emphasize that we are unique, in fact, in the patent world to do this. As I mentioned already, America does not recognize this prior art, and I think they miss an important part of an important source of prior art. Oh, I'm losing my, yeah, I was coming to the end of it. We are, I mean, I think other patent offices are really losing an important source of prior art, and we are really proud of having this and to be able to assess this important information to increase the quality of our issued patents, especially in the field of standards. Thank you.
Thank you, Mr. Sarni. Now I request Ms. Gabriel.
No, I don't need slides. Presentation, which I thought I'm going to give, had changed the last hour a little bit. But I'm still here to talk to you a little bit about SAP and FRAND and all these issues, and I'm very happy to do so. So I could start now trying to rebut some things and explain a lot of things for about 2 hours. Maybe that's not the time I get. I have about 10 minutes. I could also have it very fast and very quick, but by just one sentence, which says, FRAND works. Then I could go sit down and leave you in the dark. But I'd like to emphasize a little bit on what FRAND really is and what FRAND means. And I have to, I'm sure I'm going to be quoted, but also have a disclaimer here. This is my opinion. It's not always can be deducted from Ericsson's opinion, but what I'm saying here is really my opinion. But I'm happy to be cited because I think it makes sure that I'm saying something which is relevant. Anyhow, FRAND works. Why does FRAND work? FRAND is a range as well. I mean, we heard before FRAND, oh, it's expensive, and why does it take a large portion of all the phones and all this? But FRAND is a range. FRAND has a floor, and FRAND has a cap. At least the way we see it, at least how we offer this. So if a multi-million product like an airplane or so would be there, nobody would come in its wildest dreams to the idea and take any communication device in it as a basis for licensing. Not at all. The same in other areas. I mean, there's a floor because sometimes phones are just sold for nothing or just given for free. There has to be something because there's an attribute in the technology. And I'd like to bring your attention to this kind of smartphones which everybody now has, which now my husband calls me on. And that wasn't planned. And this is really, there's a large technology in it. And if I just implement it in this phone, of course there's displays, there's other, but what do you use this for? For my husband, I promise you, it wasn't him, I can answer. but it's for calling people. It's not for displaying things. There is an add-on, of course, but if you have a several $100 phone, nobody asks a large percentage out of this. I can tell you, and that's not a secret, that FRAND, as we see it, is a low single-digit number of this. And as said, there is a cap and there's a floor. And what is so horrible on this, or should I call it horrible? What is the problem with giving the benefit back to it? This is a phone. What do I do with it? I phone, I stream, I do. And I give you a very famous example. There's a company you all know about. They had the idea to either do a phone or do an iPod. With that, you all know who it is. Who has here an iPod in the room? I have one, but I got it as a present. So few ones. But they had a choice, and we put the phone into the iPod. There's a lot of technology in it, but we put the phone into it. When I say we, it's not Ericsson alone, of course not, and it's others. We put it in. Otherwise, you would use your phone, have downloaded, not your phone, your iPod would have downloaded something. I got an iPod as a present. It's lying at home. I don't need it. I have a phone. I can have all the functionality on it. So this is why it also shows how it works. And if we talk about what FRAND means and what FRAND, is it horrible to get money back for companies inventing all this phone technology in it? It shouldn't be, should get a fair return. But with all respect to the people talking before me, they never said you shouldn't get anything. They always said. But there was a lot of question, but I wanted to finish this wrong impression that FRAND is prohibiting anybody from the market. Not at all. Indian companies will not be thrown out of the market by FRAND companies or companies like ours having a lot of patents being out. Apple didn't have much in this field. They have not been active, but they are selling phones very, very successfully. And this is what we have to see. So FRAND enables, if we wouldn't have FRAND, no Indian company would be able to even put up a phone on the market, because the phone needs the network in the back. It needs to understand. I mean, we all talk English here. We all talk the same language. I can talk German. Ich kann gut Deutsch sprechen. But how about you? If you talk in your language, I will not understand you. And this is why we need standards, to talk to each other. And for me, it's English here today, and for this is the common SAP technology. And that I really want to emphasize. So it's so important. And I'd like you to go home and remember, at least for us and also in total, FRAND is a low single-digit number, what we are asking for. I'm not able, and you can imagine, not to tell you exactly what is a price and what it is. It's a very complicated thing, but it's a low one-digit number that you have to keep home. Then I think I got a notion of this, that Ericsson could be a troll. I mean, I'm a troll. We are not having phones anymore, but I just want to say it's the technology in total, in the network. And I mean, if I use this, if I call you, or I saw this, I'm logged into this network. The infrastructure helps me to be able to do this. Otherwise, we would have this walkie-talkies. I mean, and we could see each other. So I think there's a lot of things behind, and I think I don't like to be seen as a troll. But anyhow, let me go back to one more point, which was a little bit on the should there be injunction available. I know it's a very controversial discussion on this. I know there are different opinions on it, but I just want to invite you to the real life. I'm a technical person, I'm heading patent development, but I have colleagues who are heading licensing. The real world of a licensing person. We are sitting, we are negotiating about the patents. It's acknowledged that we have patents. I mean, nobody doubts the fact. And then you're sitting there, and then there's no willingness to pay us money for it, or you start extremely low. I mean, there's reasonable arguments where to come to. Nobody pays you, and that's the called holdout. And if you have a holdout, it's the last resort to file a litigation. And if you file a litigation, you should be allowed to all rules in the system. And I will not talk about the recent decision from the European Court of Justice, because Heinz is going to refer to it, but I just want to say there it was emphasized again that injunction is possible if you follow certain rules. So now I've tried to help a little bit what's my view, absolutely controversial, I understand, and hopefully we can have some discussions later on this. What is our view on this? But I'd like to say, also in view of India, and I very much like what was said before, do you want to be part of the race or not? 5G starts January next year. The standardization starts. In parallel, 4G continues. I mean, there will be new standards. 5G is going to be the Internet of Things, connecting everything. I mean, this is an amazing world in front of us. Be part of the game, play the standard essential game. And that's, I think, quite important. And then maybe my final remark to this, we also heard in between, there's a little bit over-declaration. Are all these patents really important? I agree, there's a lot of companies over-declaring patents, which are not really essential at the end. But then, let me go back to what I said yesterday, what I say today. High-quality patents, that's what's needed. And if I'm in a negotiation, I have to prove that my patent reads on the standard. Nobody gives me money for me saying, because I can nicely smile at you and say, could you give me some money? Nobody does it. I have to prove that the patent reads on it. And with this, I'm also extremely happy that the EPO has this, all the material from the standard essential, because then we know what is in the standard. And it happened to me several times that I got prior art, which was 3 days older, was filed by a competitor. Fine, good for him, bad for me. But this happens, and with this material, I have a better insurance that I have standard essential patents, which are very important and good and read on it. So, sorry that I couldn't give my initial speech, but I think I really liked it, and I'm really happy that you quoted me this morning so much. Please continue doing that. Thank you.
Now I request Professor Dr. Heinz Godard.
So yeah, my name is Heinz Godard. I have no idea whether my presentation will appear here. I gave it to somebody from the organizers with one slide at least to project, but we don't need this. I would like to talk about the situation with regard, I think I would say, in this field of tension between injunctive relief and standard essential patents and friend conditions. How this is presently handled in Europe, particularly in Germany. I would briefly like to refer to a Huawei versus ZTE decision of 16th of July of this year, where the European Court of Justice has decided upon a case which actually they did not finally decide it. They gave an opinion at the end of the day to what the Düsseldorf Appeal Court for Patent Infringement Matters in Germany had posed to them, namely the question, is the present practice in Germany with regard to enforcement of standard essential patents, SEPs, is this in harmony with European competition law conditions? The result was that they said it better should be reconsidered. The situation in Germany is at the moment like this. If somebody enforces a standard essential patent and the licensee makes an offer for a license under a patent he wishes to use under friend conditions, then at the same time the to-be licensee, the so-called willing licensee, deposits already the royalties to be expected from that license offer into an escrow account at the infringement court, behaves in other words as if he would already be a licensee, then the patentee cannot enforce the injunction anymore. Problem with this, how does the willing licensee, is a little bit provocative question, know what fair, reasonable and non-discriminatory conditions are? What do other licensees in this field pay to the licensor? What is the market price? How can the poor licensee do this? Keyword, Orange Book standard decisions of the German Federal Court of Justice. I briefly mentioned this. The European Court of Justice said, and this is actually what Mr. Kühnen, he is the presiding judge of the respective appeal court in Düsseldorf, will make out of it. He has publicly said this already. There are no decisions made yet. The case will be decided after the European Court of Justice has answered various questions of the Düsseldorf court on the 16th of December 2016, Huawei versus ZTE. Then we will see what they make out of it. But what will come out is the following. Yes, I fully agree to what Gabriele said. Of course, according to German Patent Act, we have automatic injunction as a consequence of patent infringement. No doubt about this, Article 139 of German Patent Act. But now there comes a twist in the whole procedure. If the licensee just declares to be a willing licensee, the so-called infringer, then the licensor will have to propose a friend condition license. And the licensor is supposed to know what the market price is, what would be fair, reasonable, and non-discriminatory. If the licensee then, the willing licensee, objects and says, no, what they are asking me to pay is by far not friend, then the court will, Düsseldorf has announced this already, request the licensor, owner of the standard essential patent, to present all license agreements he has concluded in that field already to the court, so that the court can see what the conditions in this whole thicket of license agreements is. This is what will come out. I predict this in December of next year. That means we have factually, in Germany at least, no injunctive relief for standard essential patents anymore if certain conditions are fulfilled by the willing licensee. This is in full conformity with recent decisions in Japan. You might be aware of this, of February of this year. This is the Tokyo IP High Court. This is all going into the same direction. It will go to the Supreme Court in Japan, but that will be it. And this in conformity with United States situation after a company named Microsoft was involved in this and is still involved in this. In Seattle said similar things. Judge Robert, he is traveling all around the world talking about this. No injunctive relief anymore for standard essential patents which are set by a standard setting organization. Interesting. I don't understand it quite, because why should de facto standards treat it differently than standards developed or set by a standard setting organization? But that is the case. Now, the problem with all the procedures we have seen in Germany, I was involved in the now settled cases Motorola, Google versus Microsoft intensively on the side of Microsoft. This is not secret, so I should openly confess this here. And it was always the question then at the end of the day, difficult court decisions, court in Mannheim, appeal court Mannheim, the Federal Court of Justice had not spoken a last word yet insofar, is how to determine friend. I claim, particularly when I compare the situation in Germany with the situation and decisions of Dutch courts, of courts in other European countries, British courts, that the civil courts have proven as being unable to determine friend conditions. It is just not their business, particularly not if one looks at a fact which briefly was discussed already, that usually, I think Apple at the moment says 608 patents on the iPhone. I have no idea whether this is true, but assuming that, you have, in order to determine a friend condition, not only to look at the one patent or the two patents which individually in a certain case are in dispute, you have to look at all patents that must be used as so-called real standard essential patents in order to make your phone talking with another phone. A civil court being presented with such a complex situation where several dozens, several hundred patents are used, cannot do this. Now we have an interesting provision, and this is, I wish to conclude with this proposal, but I wish also to use 3 to 4 minutes still, which I have on that, would be as follows, and it is highly discussed in the Commission in Brussels at the moment, in the Office for Standards, particularly in telecoms there. It is discussed in the German Ministry of Justice, in the German Patent and Trademark Office, in scholar circles. The German Federal Court of Justice and the judges there of the Patent Senate are pretty much in favor of this. We have the following situation. In about half of the countries of the European Union, we have, Germany included, a provision in the patent law which gives the possibility for somebody who wishes to grant a license under reasonable conditions. Doesn't that sound very similar to friend? To anybody who wishes to get a license, to register that license of right declaration in the patent register. At the moment, the only effect of that, that's why it is never used practically, means that from then on you have only to pay half of the annuities, 50% of the annuities, so not of interest. That's the last hope maybe of a patentee, still to make some money by monetization out of the patent. But if now the standard setting organizations or the courts before you could enforce even a standard essential patents of a de facto standard, would request that a license of right declaration is registered in the patent register. Then comes a second provision in this Article 24, actually in Germany, and that provision is the following. If the parties can't agree on a reasonable royalty, the patent office determines it. And if there is no agreement then of the parties, they can appeal to the German Federal Patent Court, where they handle compulsory licenses, etc. If you would use that provision in the countries involved and also in the countries which don't have this provision yet in Europe, they should possibly introduce it, you would have a different authority, namely the patent offices, determining in an arbitration-like procedure. And the German Patent Office has a lot of experience in so far because they decide similar questions, particularly with complex invention situations all the time with regard to employee invention remuneration, which is calculated based on license analogy usually. You could then, by a competent authority, in dialogue with industry, this is all the mechanism in the Board of Arbitration for employees' invention in the German Patent Office, in conjunction with industry, with interested parties, determine a reasonable royalty scheme, looking at all the patents involved, particularly looking into the guidelines for using license analogy under the German law concerning inventions made by employees, which deals with the maximum load that a product, for example, could carry in order to remain sellable if there are many patents on that product. This is all provided for. And interesting enough, I would like to conclude with this proposal, and this is what's so interesting is in the Commission, and actually Kerstin Jordan brought me that to my attention. I didn't know this, I had never paid attention to it. In the draft for the unitary patent, there is a explicit provision that also the EPO in future will have a register to file license of right declaration at the EPO, and even more interesting, the proposed rules of practice of the Unified Patent Court have explicitly the authority of the Unified Patent Court to handle decisions of the European Patent Office on reasonable royalties which they might propose for something. So I would like to propose that one looks at this also at the EPO, also in other national countries in Germany, outside of Germany, in Europe, outside of Germany, whether one should not use this provision to bring a more competent authority, namely the patent offices. In the EPO, it would mean they would have to probably create a new arbitration board for licensing, license of right declarations or whatsoever. It must be built anyway according to the law, and have these institutions decide on friend conditions. Thank you very much. That's it.
Thank you, sir. House is open for questions. You can ask maximum 5 questions. Please.
Sangamitra Mohanty, I am the professor in computer science with Utkal University. I am also the ex-vice chancellor of North Odisha University. My question, not question, I have such a suggestion, rather apprehension, that recently in India we are going to have a lot of mobile applications. Mr. Mahendra mentioned about the economic standard and of Indian, and you have not mentioned about the literacy standards. Do you think with that literacy standard and economic standard, the mobile apps is going to be a success 100%? My next question is to Mr. Saha. Without a insecure network, is mobile app going to be a success in India? And to my third question to Gabriel,